Sharia, also spelled Shariat, is one of the most complex and often misunderstood concepts in the modern world. Rooted in the Islamic tradition, Sharia is not simply a law in the Western sense, but a comprehensive moral and legal framework that governs various aspects of a Muslim's life. Derived from the Arabic word sharia, meaning a path to water, symbolizing the way to live a moral life, it is meant to guide individuals and communities in their relationship with God, with each other, and with society at large. This essay explores what Sharia is, its origins, principles, categories, sources, applications, and its role in the contemporary world. 1. Origins and meaning. Sharia is considered by Muslims to be the divine law revealed by God, Allah, to the Prophet Muhammad through the Quran and the Sunnah, the practices and sayings of the Prophet. The aim of Sharia is to establish justice, protect life, property, religion, intellect, and family, and provide moral guidance. Unlike codified legal systems that are written down in constitutions or statutes, Sharia is more of a guiding system of principles derived from a combination of divine revelation and scholarly interpretation over time. Sources of Sharia. There are four main sources of Sharia law. 1. The Quran, the holy book of Islam, believed to be the literal word of God. It contains directives on worship, morality, family life, criminal behavior, and commerce. 2. The Sunnah, the Prophet Muhammad's actions, sayings, and approvals, which provide clarification and context to the Quran. 3. Ijma, consensus, when scholars reach agreement on a particular issue not explicitly covered in the Quran or Sunnah. 4. Qiyas, analogical reasoning, using analogy to deduce new rulings from existing ones when direct guidance is not available. Some also include ijtihad, independent reasoning by qualified scholars, as an essential tool in adapting Sharia to new circumstances. Core objectives of Sharia. Maqasid al-Sharia. Sharia is not a rigid system. Its main purpose is to achieve the public good and to prevent harm. Classical Islamic scholars identified 5 primary objectives: maqasid, din, protection of religion, din, protection of life, nafs, protection of intellect, eqwal, protection of lineage family, nasl, protection of property. These form the moral and legal foundation for all Sharia-based rulings. Categories of human acts in Sharia. Unlike Western legal systems that typically classify actions as either legal or illegal, Sharia uses 5 categories to classify human behavior. 1. Fard, obligatory. Acts that are required, such as prayer, salat, fasting in Ramadan, and paying zakat, almsgiving. 2. Mustahab, recommended. Acts that are not obligatory but are rewarded, such as voluntary charity. 3. Mubah, permissible. Neutral acts that are neither rewarded nor punished. 4. Makruh, discouraged. Acts that are not sinful but are better avoided. 5. Haram, forbidden. Sinful acts like theft, murder, adultery, or consuming alcohol. 5. Fields of application. Sharia applies to many areas of life. Personal behavior, eating, dressing, hygiene, and social conduct. Family law, marriage, divorce, inheritance, and custody. Commercial law, contracts, trade, debt, and banking, especially the prohibition of riba, or interest. Criminal law, theft, adultery, slander, and drinking alcohol have specific punishments, hudud, though they are rarely applied today. Spiritual duties, prayer, fasting, pilgrimage, and charity. 6. Sharia versus fiqh. It's important to distinguish between Sharia, divine principles, and fiqh, Islamic jurisprudence. While Sharia is divine and unchangeable, fiqh is the human effort to interpret and apply it. Fiqh can vary by time, place, culture, and school of thought. There are 4 major Sunni schools of fiqh: Hanafi, Maliki, Shafi'i, Hanbali, and one main Shia school, Jafari, each with its interpretations. Sharia in practice, diversity and flexibility. In most Muslim-majority countries, Sharia is not the sole legal system. It usually coexists with civil or secular law. For example, Saudi Arabia and Iran have Sharia-based legal systems with strict interpretations. Egypt, Indonesia, Pakistan, and Nigeria use a hybrid model. Sharia is applied in personal law, marriage, inheritance, but not in criminal law. Turkey and Tunisia are largely secular in legal governance, with minimal Sharia influence. In Western countries, some Muslims voluntarily turn to Sharia-compliant arbitration councils for personal disputes, especially in family and financial matters. However, these do not override national laws. Misconceptions about Sharia. In Western media, Sharia is often associated with brutal punishments, oppression of women, or religious extremism. However, this reflects only a narrow or extreme interpretation. Key misconceptions include Sharia mandates harsh punishments. While hudud laws exist, their application is rare and highly restricted under Islamic law, requiring strict evidence. Sharia is incompatible with human rights. Many scholars argue that the principles of justice, dignity, and mercy in Sharia align with universal values when interpreted contextually. Sharia oppresses women. Sharia offers rights to women in marriage, property, and divorce, many of which were progressive for the time of its origin. However, cultural practices and patriarchal interpretations often distort these rights. 9. Contemporary debates and reform movements. Muslims today debate how Sharia should function in modern societies. Key discussions include reform versus literalism. Can interpretation evolve with time, or must it remain fixed? Women's rights. How can Sharia be interpreted to ensure gender justice? Democracy and Sharia. Is Islamic law compatible with democratic principles? Globalization and finance. How can Muslims engage with the modern economy while adhering to Islamic ethics? Progressive scholars advocate for a maqasid-based approach, interpreting Sharia in light of its higher objectives to protect human welfare. 10. Sharia and non-Muslims. In traditional Islamic empires, Sharia was applied to Muslims, while non-Muslims, e.g., Christians, Jews, followed their own religious laws under protection as dhimmis. Today, in secular or pluralistic states, most Muslim jurists agree that non-Muslims should not be subject to Islamic law. Conclusion. Sharia is not a monolith, but a diverse and dynamic tradition. It is best understood not as a legal code, but as a comprehensive framework for living a moral, just, and faithful life. Like any religious or philosophical tradition, its interpretation varies widely based on context, culture, and scholarship. While it is true that Sharia has been used to justify oppressive practices in some regimes, it also contains a rich heritage of justice, mercy, and social ethics. A nuanced understanding of Sharia requires separating divine principles from human interpretations and recognizing the diversity within the Muslim world. Ultimately, Sharia is a path, a way of striving toward a life of meaning, discipline, justice, and spiritual fulfillment.